Good evening and happy holidays to all. I'm Sheila Boston, president of the New York City Bar Association, AKA the Bar of Hope. And it's indeed my pleasure to welcome you to this disturbingly important and timely program, Protecting Our Constitutional Democracy. I would like to thank our task force on the rule of law for sponsoring the program, our election law committee, the New York State Bar Association, and the other organizations that are co-sponsoring this program. I also wish to extend my sincere appreciation to our wonderful panel members who will be introduced by our moderator, Jerry Goldfeder, one of America's foremost election law experts. As I said, I'm president of the 152 years young New York City Bar Association, which was formed in the aftermath of the Civil War by a couple hundred lawyers who had it with the corruption of Boss Tweed's Tammany Hall machine and were determined to devote themselves to building a fair and functional system of justice. I say 152 years young because in the course of history, especially in the struggle for democracy, civil rights, justice, and the rule of law, 1870 really is not so long ago. Whether you agree with historian Eric Foner that the Civil War and Reconstruction marked the quote unquote second founding, recent events in these United States reveal a nation still learning how to walk and learning the hard way that the best way is not one step forward and two steps back. It was only in recent years that the City Bar was compelled to create a task force devoted to protecting the rule of law. And it was only in recent months that the City Bar, through the task force and our election committee, was compelled to put out a report on protecting our elections and the right to vote. Please take a look at it. It's on our homepage. Read it and share it widely. Despite many of us being exhausted by the politics and the not unconnected racial reckoning and global pandemic that have dominated the past several years, we are here today because we recognize that the task of defending democracy in America did not end with the 2020 election, but rather is just beginning. State legislators are enacting a host of voter suppression laws, claiming they must do so to restore voters' faith in our election systems. Notwithstanding that any such lack of faith, in large part, is the fallout of the patently false and propagandistic claims that the 2020 election was quote unquote stolen. We have to wonder and worry whether local election officials will be able to withstand in future elections the sort of bad faith and frivolous challenges to vote counting that occurred following the 2020 election. The City Bar's voting rights report is titled The Consent of the Governed, because the right to vote is the bedrock foundation of our democracy, our most fundamental right, and the one that makes all our other rights possible. Immediately after declaring the unalienable rights of life, liberty, and the pursuit of happiness, the Declaration of Independence states that, and I quote, "To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed," unquote. And consent of the governed is derived through the votes of the people. Efforts to restrict or undermine equal access to the ballot are a direct threat to the democratic process and the rule of law in our nation. To defend the right to vote is to defend democracy, and to call good faith defending of the right to vote political or partisan is to engage in sophistry for political ends. As lawyers, we are officers of the courts and are pledged to respect and enforce the rule of law in accordance with the constitutions of our nation and our respective states. That's why we are urging every lawyer, every law firm, every corporate legal department, every law professor, every law student, every law school, and every bar association to recognize the central relevance of this issue to their profession. After all, the legal profession itself is meaningless without the rule of law. Now, What else can lawyers do, you may ask? Well, we can volunteer to be poll watchers or observers of vote recording and counting, or defenders of officials who administer elections and report results in accordance with applicable law. As many of them have recently become American heroes, in my opinion, as they have demonstrated courage and tenacity to withstand the vitriol and threats that have been directed upon them. As lawyers, we can litigate. We can support federal voting rights legislation, as well as fixes to the filibuster to make federal voting rights legislation possible. And we can use our voices and our platforms, like this one this evening, to speak out, to educate, and to engage with lawyers and members of the public to protect our electoral process and preserve our democracy. I believe that's what the founders of this bar association would do if they were in our place. I have hope and sincerely believe that they were principled and, if alive today, would stand up for the rule of law. So may we too be principled, keep faith with their spirit, and do the same. I thank you so much. And now it is my pleasure to turn the program over to our moderator for this evening, the one and only Jerry Goldfeder. Thank you.
Well, thank you very much, Sheila Boston. Although you can't hear me, we do appreciate the leadership that you have demonstrated throughout your tenure to emphasize the importance of voting rights and the importance of the role of lawyers in preserving our constitutional democracy and saving our republic. Sheila mentioned a report by the Rule of Law Task Force called Consent of the Governed, which is on the New York City Bar Association website, and I urge all of you listening to go to it. The chat has put a link to one of the things that lawyers can do is to sign the pledge of certain principles, 9 principles in support of voting rights. So I urge you to do that as well. I'm privileged to be here today, and I want to thank Stephen Cass, who is on this site, who is the chair of the Rule of Law Task Force of the Bar Association, who graciously invited me to moderate this program. This is a terrific group, all of those who have tuned in today, and I welcome you. We have 3 of the leading election constitutional scholars of our country. We're just delighted that you are here with us today. All the way from California, we have Rick Bazin, who is a prolific author and really one of the leaders of the election law bar. He is a professor of law and political science, and he's also the chair, co-director, I should say, of the Fair Elections and Free Speech Center that he just initiated at UC Irvine. In the middle of the country, we have Derek Muller. I think I was in the middle of the country, a professor of law and also a terrific author who has joined with us many times before. And Deborah Pearlstein, who is here from New York City, Cardozo Law School, who is the co-director, I wanted to get it right, co-director of the Florsheim Center for Constitutional Democracy. All 3 of my friends here have contributed and continue to contribute to the importance of the scholarship and advocacy relating to protecting our constitutional democracy. I have the privilege of chairing the Voting Rights and Democracy Task Force of the New York State Bar Association. And so what we're doing here today is something that more and more of us in the legal profession are involved in. And those of you who are listening tonight or by recording later after this program, I urge you to participate in the way that Sheila Boston has mentioned, and in ways that fit your schedule and responsive to your own set of interests and the needs of our republic. So what we're going to do is we're going to have each of our panelists address the issues for about 15 minutes each, and then we will throw this open to questions and comments, which you're invited to register on the Q&A. We don't have a chat, but you can write down your questions or your comments in the Q&A, and we will deal with that after the three panelists make their presentation. We're going to look at where we are, how we got here in 2021, the constitutional framework that we have for our elections, particularly the Electoral Count Act, a law that was passed in 1887, and that we witnessed its frailty in the 2020 election. And then we'll look at, as Sheila alluded to before, some of the laws that are being enacted as we sit here today that are undermining and subverting the voting rights of the people of the United States. And then we'll address the issues of what we can actually do to preserve our republic, to preserve the rule of law and our constitutional democracy. So we're going to start with Derek Muller, Professor Muller, and we'll go then to Deborah Pearlstein, and then Professor Rick Hazen. So Derek, please take it away.
Well, thank you so much, Jerry. Thanks for the kind invitation. It's a privilege to be on a panel with Deborah and Rick. So when we talk about presidential elections, it's complicated in the United States. Let's just start there. We can think about elections in the United States, the federal and state level, but presidential elections are run differently from congressional elections. The states have principal responsibility, but it's really 50 states in the District of Columbia, each administering their own presidential election. And maybe we can talk about some of the reforms that can affect our federal elections. But what happens is when we have a presidential election that happens in these states, then choose presidential electors, again, the sort of ancient mechanism that was developed in the 18th century that thought we would have these independent actors who would choose the best person as the president. Very quickly, we realized they would be party loyalists who would essentially ratify the political party's nominees. And then those votes are sent to Congress, and Congress, in theory, has a pretty simple job of counting the votes, figuring out who has a majority. If there's no majority, it gets kicked to the House of Representatives to vote. If there is a majority, we have a president. So there's several stages that happen there. And obviously January 6th of this year, not just for the riot initiated by a number of vigilantes in Washington, D.C., but January 6th every 4 years is the day set by law for Congress to gather and count the electoral votes. So it's not a remarkable proposition. Someone's got to do the counting, and the Constitution says that the president of the Senate, typically the vice president, opens the envelopes, and then in the presence of the House and the Senate, the votes shall then be counted. So there's a little bit of complexity there in the 12th Amendment, the use of the passive voice. But I'll describe a little bit about the history of how we get to sort of the counting rules we have today, how the counting rules played out on January 6th, and then I think some of the look at reform. Originally, Congress just kind of gathered together. They would appoint some tellers. The tellers would sit up front and they would list the votes as John Adams or Thomas Jefferson read them aloud. And it was recognized very early that this was an act of Congress in this unusual proceeding where both houses are meeting at the same time counting electoral votes. And there were people who disputed, well, what happens if we have a fight about the electoral votes? What happens if the electoral votes come in on the wrong day, or it's by somebody who's ineligible to serve, or it's cast for a deceased candidate? And these never really reared their ugly heads in the very early years of the Republic. But right after the Civil War, we saw a number of really fragile instances of democracy. If we think about Reconstruction, in 1873 and 1877, where there were serious disputes about Southern states under Reconstruction. There was a candidate who died after the election, but before presidential electors met. There were rival slates of electors submitted by multiple states to Congress in 1877. And these all really pushed against Congress's instinct, which had largely been a kind of go along kind of process to say, if someone's got an objection, they raise an objection, we'll hear it and we'll figure it out. And without getting into the long history of 1877, the lesson came out of it were I think, twofold. One is there needed to be more trust of the states and what they did with their elections. Congress was really not supposed to relitigate or investigate what the states were doing. Now, even in 1887, that's a controversial proposition, right? The South is sort of at the end of Reconstruction, and there's potentially Jim Crow on the horizon. At the same time, there's a recognition that relitigating what happens in elections is perhaps not the best place for Congress to inject itself in a dispute, because the elections of presidents are really supposed to be distinct from the congressional role in choosing presidents. The second was that there should be a presumption that Congress counts electoral votes. It used to be that if one house didn't want to count electoral votes, then those electoral votes wouldn't be counted. That created some incentive. All you needed was one majority in one chamber to essentially thwart a presidential candidate. And so the thought was we needed to ensure there are mechanisms in place that we would prefer counting electoral votes. So in 1887, after a number of fits and starts over the preceding decade, Congress enacts the Electoral Count Act. It's been essentially unamended ever since. It's still the thing that governs how Congress handles these disputes today. And there's a large number of provisions, many complicated, some still contested today. But the gist of it essentially is this, that the first preference is to say, states, get your act together as quickly as possible and resolve your disputes ahead of when the presidential electors meet. And so sometimes there's a date known as the safe harbor date. Get your electors and get any disputes in place 6 days before the day when presidential electors meet. If the electors meet December 18th, get your act together by December 12th. That's a relatively short period of time when we think about the amount of litigation, disputes about recounts and so on. It can take about 5 weeks. And that date was really significant in 2000 in Bush versus Gore, as they're trying to count votes and recount votes and resolve the dispute in Florida. Next, once those states send their results, if there's one set of results from the state, one set signed by the executive, then Congress just counts one thing. There's not a lot of controversy. And only if a member of the House and a member of the Senate write something down to object, will the chambers separate. Each chamber will deliberate for up to 2 hours. They'll consider the objections about whether or not to count that one state's one slate of electors. And then they'll come back and make a determination. And both chambers of Congress have to agree to throw out the electoral votes or to sustain the objection. Again, the thumb is on the scale of trusting the state process and counting the electoral votes. And if there's multiple slates, there's some confusing and complicated procedures, but we've only had one of those in the last 150 years. And thanks to Richard Nixon's magnanimous concession in 1961, we didn't have a whole lot to worry about that. So usually since 1887, this mechanism has worked very well. States send one slate of electors, they resolve their disputes, Congress counts them without controversy. In 1969, there was a controversy about whether or not an elector for Nixon who voted for George Wallace should be counted, and Congress debated that. But really, we didn't even think about the Electoral Count Act very much until 2001, because after Bush versus Gore, a number of members of Congress began to object or attempt to object to say, well, maybe we shouldn't count Florida's electoral votes. But these were only members of the House. No senator joined them, so we never considered the objection. In 2005, a member of the House and a member of the Senate each objected to counting Ohio's electoral votes, saying that there was voter suppression, voting machines were improperly used, there were long lines at the polls, and so on. So that objection was considered for 2 hours. Both houses considered it. Both houses rejected the objection. They counted Ohio's electoral votes. In 2017, there were a number of objections raised by members of the House, but no senator joined them, so nothing was considered. And then we get to 2021. There were obviously many things that President Donald Trump and some of his advisors, Rudy Giuliani and others behind the scenes were trying to do, trying to get Vice President Mike Pence to reject counting electoral votes or send the matter back to the states. Those are not things the electoral count anticipates or allows. And I think the strong view of history for 250 years is that Congress counts votes, not the vice president, although we could talk about that in the Q&A if people have a question. But there were 2 objections filed, one in Arizona and one in Pennsylvania, where members of the House and the Senate signed on. There were other objections attempted to be filed by members of the House, but no senator joined. And so in each of those instances, the Houses had to separate. They spent 2 hours debating. They voted. Neither house accepted the objection, so they counted the Arizona electors. They counted the Pennsylvania electors. So we got through the process. So the process in 2021 might have looked largely like it did in 2005, but for the fact there was obviously a riot that interrupted and delayed the proceedings extensively, coupled with all of the controversies surrounding what the vice president could do in unilateral authority there. So thinking ahead or thinking forward to what we want to think about when it comes to Electoral Count Act reform. I'll just say it's complicated. I think that the key in thinking about reforming or improving the Electoral Count Act can sort of work at the margins in some places. Right. So one suggestion might be, well, right now it's one member of the House and one member of the Senate can essentially force Congress into 2 hours of debate. What if you raise that threshold to a fifth or a fourth or a third of the members of Congress? And that essentially makes it much more difficult for anyone to sort of gum up the works and slow things down. So you can pick at some of those sort of small procedural things to speed up the process. Another is to say, well, maybe we want to provide greater guidance to what states should do or what state actors ought to do. And say, you need to resolve these things by this date, or maybe we should move the dates back. We should trust what the canvassing boards do and so on. But, with any kind of increase in particularity or precision with a statute, there are obviously unanticipated consequences. So we saw, I think in the past week, the candidate running for Georgia's governor or for governor in Georgia indicated, well, I wouldn't sign a slate of electors from Georgia if I thought they were fraudulent. Well, so if we have a rule that increasingly says, well, if you sign this, then Congress shouldn't dispute what happens if you move it back a step and a state governor or state secretary of state says, I don't want to sign it or I won't sign it. We can go to court, we can petition for mandamus, we can try to get those things, but we've sort of moved the problem in a different direction. Or another is we can provide guidance to the state legislatures and say, you have to have your disputes resolved by this date, or you have to figure out who your slate of electors is based upon statutes that you've put in place ahead of election day. And this avoids some of the problems of the legislature showing up in late November, early December, writing petitions saying, we're going to choose our own slate of electors. We're going to choose our own presidential electors and send them along to Congress and say, we are the true electors. And some attempted that. Nobody had any state sanction to do so this election. There's the possibility it could happen in the future. Any of these sorts of decisions then create additional messiness, as other state legislatures might choose to say, well, let's create mechanisms ahead of election day to seize that power for ourselves. Let's provide opportunities for us to choose alternative slates of electors. And finally, some members of Congress might look there and say, why should we trust states? This notion that we should trust the states, we have actually a deep distrust of states. And you can see that rhetoric sometimes from the right and sometimes from the left in the last 20 years to talk about, we don't trust the results coming out of states in presidential elections. And so sometimes it's uneasy for Congress to relinquish its authority to review these decisions to the extent it has it and say, we're essentially going to trust what's happening in the states and trust what's happening in the state governments when it comes to the choosing of presidential electors. So moving forward, I think there's a sense in Congress, and again, it's nascent and you only see it sort of bubbling up in some media reports right now, that something should be done, that there should be a smoother process, whether that's reducing the vice president's role to alleviate that temptation to exert authority, providing greater clarity to the states, making it more difficult for Congress to object or toss out electoral slates, whatever it might be. There's some appetite to reach, I think, some bipartisan consensus moving forward. But with any kind of complicated piece of legislation, anytime you push in one direction might yield opportunities elsewhere for mischief. And so I think as we think about reform efforts, it's going to take a lot of puzzling and thinking through solutions as we think about the best way of counting electoral votes on January 6th, 2025. Thank you.
Well, thank you so much, Derek. So after the insurrection and after what occurred in Congress, we see the states are asserting themselves in ways that may not be so democratic, small d. Deborah, why don't you address that?
Sure. And let me start by thanking you, Jerry and Stephen and Sheila as well, for putting together the panel and for including me. I too am just honored to be on a panel with Rick Hazen and Derek Muller. So it's great to be here. Okay, so why is it that so many both democracy scholars and election law experts and others are worried about not just particular voting rules, but the fate of democracy sort of writ large in this context? And to talk through and to kind of try to summarize what is in fact a large and sweeping set of changes across 50 different states in the United States that is continuing even as we speak, I thought it might be useful to back up for a minute again to the 2020 election and think about what worked in that circumstance, right? So even though ultimately the Electoral College vote ultimately, right, was reasonably lopsided, Biden ends up getting 306 Electoral College votes, right? And there's at the very end, no question that, right, that counts, or that is enough Electoral College votes to secure the presidency. In fact, the election is, in an electoral college sense, extremely close. So if the votes in 2 or 3 different states, which end up being very closely divided, go in a different way, or if the voters' preferences in those states end up not being accurately captured by vote counting or the certification of those votes, right, then we're in a very different position. So why is it that, for example, votes were accurately counted and electoral votes certified in Georgia or in Michigan or in some of the other states, Arizona, for example, where the election was very close? Why did this work on this occasion? And I want to cite, although I think there are several checks that proved to be pretty important in these circumstances, I want to highlight 3 in particular, right? So one was the role of state election administration processes and state election administrative officials, right? And so there are some examples of this that are, I think, really well known to most folks who followed the 2020 election. People like the Republican Georgia Secretary of State, who resisted extraordinary pressure from a variety of corners to either shift the vote count or not move forward with the certification. The Georgia Republican governor was in a similar position. There was a singular Republican official on the Michigan State Board of Canvassers who similarly was under intense pressure not to certify votes from particular heavily Democratic-leaning counties in Michigan. So we saw really, I think, courageous, but nonetheless professional, or simply professional behavior by election administrators under extraordinary pressure, including threats of violence, to simply say, no, this is the process, this is what we're going to do, this is what happened, there is no actual evidence of fraud, and to move forward, not only at the professional election administrator level, but also Republican governors in Arizona and Georgia, to say we're going to certify and recognize this vote. So that was one set of system, this sort of professional, at least semi-independent mechanism through state election administrators up to and including secretaries of states and eventually governors. So that's one. A second check that I think proved remarkably and maybe surprisingly significant was the courts. And we can debate the extent to which this was significant later. But the courts ended up playing an important role in 2 respects. One is in the post-election period, in the face of dozens and dozens and dozens of challenges that were filed claiming fraud and different sorts of election irregularities in jurisdictions all over the country, we saw a remarkable consistency, both from courts which were in which democratically appointed judges served and courts in which Republican appointed judges served, to say, there is no evidence of fraud that you are claiming, or your claims are otherwise baseless, right? And to behave as we might hope and expect courts would behave in the face of claims without evidence and the like. It didn't have to be that way, right? And we can talk about the role of the courts going forward, but I think that was nonetheless significant. And you saw even in the pre-election period, where there were similarly dozens of challenges to changes that were made in states to respond to the COVID emergency, to try to make it easier to vote, to extend voting periods, to expand the number of, for example, drop boxes and make it easier to vote in various ways. Those efforts were challenged in the pre-election period. And not all of them survived, right? But what we never saw was a ruling, for example, by the Supreme Court that said, actually, state election administrators and courts have no power to change anything that the state legislature established in the first place, no matter what else is happening in the world, right? We could have seen such a ruling, and I'll come back to the danger of that. We didn't see that either, right? So those actions and inactions were significant. And finally, I think a really significant feature of the ultimate conclusion of the election, right? Notwithstanding the extraordinary violence that we saw on January 6th, was the reality that Americans' faith or confidence in election systems was still at a reasonable or at least sufficient level. So to give you a sense of what I mean by that, Gallup and other major polling organizations, but let me just start with Gallup because they've done a tracking poll of Americans' confidence in election systems over periods of time. If you look at Gallup polling data about Americans' confidence in election systems in the United States, in 2018, for example, roughly 70% of Americans indicated that they were very or somewhat confident that votes will be cast and counted accurately across the country. By 2020, that number had already dropped quite a bit to 59%, right? And that drop was driven principally by a drop of about 34 points among Republicans and Republican-leaning independents in their confidence in election systems. But nonetheless, the overall degree of confidence across Americans was sufficient that we didn't see significant violence or disruption of election processes on election day, right? Many of us worried we might see that. That didn't materialize, and unsubstantiated claims of fraud were rejected not only by the courts, but also by the media and the military, and indeed a huge majority, roughly 70% of the American people who continued to believe, in fact, that the election was conducted fairly and there was no fraud and so forth. So all of those things, I think, and some others, but those factors in particular, election administrations, the courts, and sort of public faith in electoral processes proved, I think, pretty significant in producing the outcome we saw in 2020, that is with Biden being inaugurated as president on January 20th. So what has happened since? And here is where I think we start to see really significant, troubling deterioration in each of these metrics, right? Or each of the stability and the effectiveness of each of these checks. So if you think about just the two voting officials I mentioned, right? The Georgia Secretary of State, the young Michigan Republican member of the Michigan Board of Canvassers, the Republican member of the Michigan Board of Canvassers has been removed from his office, and we have seen similar purges of election officials in jurisdictions sort of across the country. Elected officials like the Georgia Secretary of State, like the Republican and Georgia elected governors, face significant primary challenges to their authority. And we see many more election officials who aren't elected departing from their jobs under pressure of, among other things, violent threats, which is something that I'll come back to. But those are just in particular instances of the particular checks we saw, right? Much more systemically, or indeed systematically, we've seen about 24 states enact laws that weaken in one way or another the independent operation or increase the partisan control or partisan influence or involvement over state election administration in one way or another. So let me just give a couple of examples of these. So some legislation, and Georgia is a fine example here, have given partisan state officials like the legislature increased powers to remove election officials at the county and local level, or even to seize control of election administration altogether during an election if they conclude under the terms of Georgia's law that they have found malfeasance or gross negligence, right? So in practical terms, this gives, for example, the Georgia legislature, the Republican-controlled Georgia legislature, the power to displace election officials in Cobb County, for example, in Georgia, or heavily Democratic-leaning counties in Georgia, if they don't like the way the election administration is going, to simply remove those officials in the midst of election processes and supplant the legislature itself or put in place their own officials instead. So that's one kind of category of legislation we've seen. Another category, and a number of states have done this, Arizona, Iowa, there are several others, is to create new criminal offenses and civil penalties on election workers, so from poll workers to election administrators, for violating particular rules of election administration. And some of the rules of election administration, you would like there to be criminal penalties that attach if they are violated. But a lot of these laws are aimed at not being sufficiently, officials who are not sufficiently aggressive in purging voter rolls from people who haven't voted in recent elections, or violating the rule that prohibits a poll worker, for example, from walking the ballot of a disabled person into the polling booth themselves if the person doesn't want to get out of the car, right? That particular rule is designed in principle to prevent voter fraud. But in fact, right, the rules are written broadly enough and enforced in such a way that they leave enormous room both for over-enforcement, selective enforcement, and maybe most significantly, a real chilling effect on poll workers and election officials who are operating otherwise in ways that are relatively normal and certainly pose no threat of fraud. So that's a second set of concerning developments. And then a third at the state level is empowering poll watchers and independent poll watchers. And I want to distinguish here between poll watchers and poll workers, right? Poll workers are people who, for example, are employed by the state or the locality to do their jobs. Poll watchers typically are people often partisan individuals who the parties bring to the polls to observe and make sure elections are going on as they should. In states like Texas and Florida in particular, we've seen new laws that give partisan poll watchers in particular extraordinary access and rights to engage in the operation of any polling place. So requiring partisan poll watchers to have free movement entirely throughout all voting locations, giving them a right to an unlimited number of challenges to each ballot's validity, right? So in addition to both potentially posing the danger of having all these people in the polling location and making it a lot harder to carry out elections in a sort of orderly way, one of the real risks of laws like these is a chilling effect. That if you have this many people there and people in particular who are targeting their checking measures at particular voters, you raise the risk of intimidation and chilling not of the behavior of election officials, but of voters themselves, right? If I have to go through this gauntlet at the polling place, why would I even bother to vote, right? So that's at the state level, and there are lots more examples, but in the interest of time, I want to just stop there with a bit of a flavor. The second, briefly, are the courts, right? Since the 2020 election, we have seen one of the key tools, statutory tools available to challenge changes in voting procedures and rules, sort of limited Supreme Court case called Brnovich, significantly limits the scope of Section 2 of the Voting Rights Act, which makes the Section 2 of the Voting Rights Act is designed to make it possible to challenge changes in voting procedures that have that impose disproportionate burdens on minorities and other groups. The Supreme Court just this past term significantly narrowed the scope of that rule. So now it is much harder for plaintiffs to prevail on claims under the Voting Rights Act. And this is in the face, as was mentioned at the beginning, of at least, according to the Brennan Center, 19 states enacting 33 different laws that in one way or another make it harder for people to vote, either by narrowing the ability to cast an absentee ballot in certain circumstance, eliminating or reducing the number of drop boxes for voting and the like, right? So challenging those in courts have gotten a lot harder. And we learned in 2020 that in fact, both at the Supreme Court level, and we see this now playing out across the country, the argument that state courts and state election officials have any independent authority beyond what the legislature itself does to set the time, place, and manner or rules for voting in federal elections, the argument is under what shouldn't be called a doctrine, but which is currently called a doctrine, right? It doesn't exist. No court has ever recognized it. But the notion is there is this independent state legislature rule that is required by the federal constitution that says only state legislatures, not state courts, not election administrators working to respond to a crisis of one kind or another, have the legitimate power to set the rules. And to the extent there is any challenge to what those legislatures have done, they are not cognizable in federal court. So concerns among many others of those two particular issues at the court. And then finally, I want to come back to the issue of public faith. And here, the fact that there has been this concerted, incredibly effective campaign to the Stop the Steal campaign, or the whatever you want to call it, to say that in fact the 2020 election was fraudulent. When I say incredibly effective, what I mean is, according to a variety of polls, roughly 2/3 of Republicans, compared to about 3% of Democrats, believe that Biden's election was the result of fraud of one kind or another, right? So we see mammoth loss of faith that varies hugely by party and along partisan lines. This is worse than sort of the typical partisan variation one sees after your side loses an election, right? One always sees some diminution of faith by the losing side of an election. But here, the percent of Trump voters in 2020 who said they weren't at all confident that their vote was tallied accurately was about 4 times higher than the percent of Clinton voters that said the same in 2016. So why does this matter? And why does it matter that's a partisan effect? Well, one effect, and this remains to be seen, right? But some have argued that the salience of election and democracy concerns in particular are much higher. That is, Republicans care much more right now about elections and voting rights and election rules than Democrats do. So that might be one effect. But the effect that I think democracy scholars worry most about is the increased risk of violence. And we see this not only in the staggering number of threats against actual election workers, current election workers of both parties. But we can see this as well in public polling, in which we have seen, so for example, in January 2020, when pollsters looked at whether Republicans agreed that a time will come when patriotic Americans have to take the law into their own hands, right? 41% of Republicans agreed with that proposition in January 2020. Now that's a staggering percentage in important terms. But by January 2021, that percentage was up to 56% of Republicans who believe that the time will come when patriotic Americans have to take the law into their own hands, right? And in similar polls, right, and these aren't political polls, right? These are sort of public opinion polls and polls done by political scientists primarily. More than 2/3 of Republicans and half of Democrats polled say things like the other party or members of the other party, to the extent they believe one thing or another, are something less than human, right? And as we look comparatively, globally, at circumstances in which previously democratic societies or stable democracies have begun to collapse, and we have an unfortunately growing number of examples of those cases in the last decade or so, we see this kind of indicator, right, along with several others that we have here now in the United States, as real warning signs that the risk of violence, as bad as January 6th was, maybe even worse now than it was then. Now, there's some caveats I can give to this. There's some things that I think we can do yet to ameliorate the circumstance. But I think in the interest of time and wanting to hear what Rick has to say about all this, I want to stop now and look forward to your questions and discussion.
Thank you so much, Deborah. This is a very sobering picture that both Derek and Deborah have portrayed here tonight. We have an Electoral Count Act, which is ambiguous and problematic. We have laws in the states that are, as we speak, as I said before, are restricting votes, restricting voters from exercising their constitutional rights and criminalizing some of the conduct that is required by poll workers to make certain that votes are cast and counted properly. So what do we do, Rick Hazen?
We throw up our hands and give up. Well, I guess you want a longer answer than that. It's great to be with you. Thank you to Jerry, Stephen, and Sheila, and it's great to be with Derek and Deborah. So just to kind of summarize where we are, if you take what Derek has told us and what Deborah has told us, we can see that as we approach the 2024 presidential election, things are dicey. Presidential elections are so convoluted, as Derek explained. There's so many different places where things could go wrong. And there are lots of people who are not going to be confident in how that election is run. Deborah mentioned the Republicans who are not going to be confident. But let me add that there are going to be many Democrats who are not going to be confident as well. And that's going to happen because the Brad Raffenspergers of the world, the Republican election officials who stood up to Trump and who followed the rule of law, many of them will be removed from office by the time the next election rolls around. If someone who embraces the big lie is the Secretary of State of Arizona or of Georgia, how are people going to believe that the election is going to be fairly conducted? And so we're going to be facing a crisis of confidence in 2024 that's going to be even worse. And so it's kind of a boomerang effect that comes, and we haven't mentioned Donald Trump very much, but we can lay it right at his feet. He relentlessly gave out the message that the election was being stolen, despite all evidence to the contrary. There's no reason to believe that the election was illegally run or there was fraud in the election anywhere in the United States that would have made a difference to the outcome. So I can see three paths to a stolen or subverted election in 2024. I spell these out in a paper I have coming out in the Harvard Law Review Forum, and I'll put a link in the chat when I'm done speaking to a draft of that paper. But there are three paths. One path, which Deborah alluded to, is state legislatures relying purportedly on a very muscular reading of the independent state legislature doctrine that I think even most people who believe that there is something to that doctrine would not embrace, which is just a overwhelming the rule of the people on flimsy grounds in saying that somehow there were irregularities in the election and the state legislature has the power to simply declare the loser the winner. If Trump narrowly loses in the way that he did last time, I think it's very possible that the Arizona legislature or the Georgia legislature would send in an alternative slate of electors, and that Kevin McCarthy, if he's Speaker of the House, would accept those. And Kamala Harris, the vice president, might rely on the John Eastman memo and claim that she can just simply reject those. And as you can see, the makings of a constitutional crisis very easily. A second way the election might be subverted is through election officials simply messing with the count. If you think that your election was stolen the last time, you might be more willing to steal it this time. And we've depended so much on norms and good faith and people of integrity to run our elections. What if they're replaced by people who think they're doing the right thing, but end up doing the wrong thing because they're trying to right this supposed wrong from 2020? And the third possible way things could go south, as Deborah also mentioned, is the possibility of violence directed at those who count the votes, those who cast the votes, those who run polling places. So I think we need to think about both legal and extra legal ways of trying to counter this. And the reason we need more than law is because law is only as strong as people's willingness to follow it. And if people are going to be lawless, then law is not going to be constraining. So what kind of changes? First, I would say we need improved transparency, chain of custody, and auditing rules for running elections. There's still about 12% of Americans who vote on voting machines that are fully electronic, that don't produce a piece of paper that can be counted in the event of a need for a hand recount. In this kind of era of distrust, we need physical evidence. We cannot rely on code in machines as the basis. And so there are a number of things that Congress could do. This is part of some proposed congressional legislation. We need to make sure that that there are risk limiting audits and other things done to assure that our vote counts are accurate. Second thing, building on the stories that Deborah told us about certification in Michigan, is we need rules that limit the discretion of those in the process of translating the voters' votes in each state into final electoral college votes. There shouldn't be unnecessary people in that process, and there needs to be validation of results by people who are actually involved in the counting and tabulation, but not ceremonial people who could gum up the works. Third, we need rules to limit the over-politicization of election administration. Deborah again mentioned the law in Georgia that would give state officials the chance to take over local election bodies. Sometimes state officials need to take over local election bodies. This is very tricky because there are often problems with competence, but when it's done for partisan reasons, it does raise concerns. And so I think there are some laws that could be put in place to deal with that. We need to increase the criminal penalties for trying to obstruct in the in the voting process or in the tabulation of votes. We already have some laws on the books. They can be strengthened. And we need rules for countering disinformation involving elections. And that raises a whole question about speech in the First Amendment. I have a book coming out in March called Cheap Speech that addresses that topic more directly. Even if we got all of these changes through, and I would say that when I'm thinking about removing discretion, I would go back to Derek's comments about the Electoral Count Act. I think we need much more clarity in the Electoral Count Act to counter these kinds of problems. But even if all of these changes happen, it may not be enough because we still rely on people acting in good faith. And so what do we need to do? We need to first organize politically. Business groups, civic groups, labor unions, churches, bar associations, and Democrats and Republicans and independents united on the rule of law. So we can disagree about substance, we can have different views on tax policy or immigration policy, but we all should agree that we should have a fair election system where every eligible voter, but only eligible voters, get to cast a vote that will be fairly and accurately counted. I mean, that's all, you know, if we can agree on that and stand together, well, we can do a lot. And so if you look at the laws passed in Georgia and Texas, for example, they could have been a lot worse, and they weren't as bad as, on the question of subversion, they weren't as bad as they were initially proposed because of pressure from business groups and others. So for example, the original election bill in Texas had a provision that would have made it much easier for a state court to throw out the results of an election and to declare the loser the winner. And that provision was stripped from the bill. There needs to be lawsuits, not only to try to get the courts to make change, but also to raise the consciousness of the public about these things. And again, the more this can be done on a bipartisan basis, the more this can be done on a super political basis and not a partisan basis, the better it's going to be. I'm hoping that the January 6th Commission will produce some pinpointed changes that people can organize around that will, you know, separate out the more controversial questions about dealing with voter suppression, which is a loaded term between Democrats and Republicans, and focus specifically narrowly on the risk of subversion. And most importantly, we need to mobilize everyone for the period of January 2025 to make sure that there is pressure on state legislatures and pressure on Congress to do the right thing, whether it's Democrats or Republicans who are being pressured not to follow the will of the people. It needs to be the case. We all need to agree that we need to hold a fair election, and the results of that election need to produce a system where the winner is actually declared the winner. It is heartbreaking for me to have to say that in the United States, that we even have to worry about something like this. I never thought we'd have to worry about this in the United States, but here we are, and now's the time for action. If we wait till 2024, it's going to be too late. And let me stop there so there'll be time.
Well, thank you very much, Rick. So one of the issues that you've identified, that Rick, you've identified, is good faith, and we learned in 2020 that the law, no matter how much we revere it as lawyers, goes only so far. There are norms that need to be addressed, need to be embraced. And if they're not, irrespective of the law, then things break down. We've had 11 presidents who ran for re-election who were defeated. Only the last one who was defeated didn't respect the norms. And even with all the laws in place, he didn't act in good faith. His supporters didn't act in good faith. How do we restore that? How do we restore the norms of peaceful succession, of fair elections? How do we restore that in this atmosphere of deep distrust and partisanship in our country?
Is that directed to me?
It's directed to all three of you.
Yeah. Well, I guess I'll start since I started speaking. I mean, this is the key question. I think as hard as law reform is, changing people's attitudes is even harder. And so long as Donald Trump is on the scene, making claims about the false election, it's going to be very difficult. One of the most troubling polling results, which Deborah didn't mention when she mentioned a number of troubling polling results, but one of the most troubling was 59% of respondents in a recent CNN poll said that believing Trump's claim that the 2020 election was stolen was an important part of what it means to be a Republican. So it's become kind of the identity of the Trumpian base of the Republican Party. And so I really think that it's going to take courageous Republicans standing up. And that's really hard to do because look what's happened look how Liz Cheney, look how Anthony Gonzalez, look at the people who voted for impeachment on the Republican side, or Brian Kemp or Brad Raffensperger, two conservative Republicans, how they're being now primaried. It's a very tough question. And so wherever it's possible to find Republicans who do not buy into the big lie, and to find Democrats who are willing to recognize that they're not going to agree with Republicans on everything, but we can all agree on the rule of law. That's where we have to form a kind of center coalition to the extent that it's possible to try to assure that we continue to have fair elections.
And let me just add briefly, it's so strange that Republicans have won a lot of elections in the last 14 months. If you think about the number of Senate and House elections they won in 2020 outside of the presidency and on the same ticket as the presidency, when you think about the Virginia elections just last month and actually some of the success even in New Jersey among Republicans. And so it's a very frustrating thing to try to speak to Republicans who are fixated on the sort of fraud in the presidential election and yet recognize that there's lots of success for their party at the moment in a lot of other places too. So yeah, it really is, if you want to say big lie, if you want to focus on really President Trump's 2020 sort of emphasis, it's sort of a fixation that just is not going away anytime soon. And I don't have any easy solutions to it, except sometimes to point out, it's not like Republicans are losing everything. In fact, they're probably going to win very big in 2022 as well. But all eyes are going to be on 2024 and what that means.
Yeah, so I guess piggybacking on part of what Derek and Rick said, I guess I think about, well, I think about one category of reforms, right? And those are just very concrete legal changes that I view as low-hanging fruit that might help clarify some of the basic, so that we don't hit these sort of speed bumps unnecessarily, right? So reforms, for example, to aspects of the Electoral Count Act, which are needlessly confusing and obscure, those kinds of changes. There are similar kinds of changes that we can make and should make at the state level to federal law. Rick's point about the need for paper ballot trail is something that we've been talking about for 20 years or more. there is and should be enormous bipartisan consensus on that point alone, and that just needs to happen, right? So there's a whole bunch of common sense reforms that could and should happen, and people should vote for them and should push their representatives to vote for them, and maybe they will, right? So I don't want to discount the significance of those measures. They should happen, and they're really important and can help avoid some bad outcomes without question. But the broader question you're asking is, how do we deal with this level of public confidence and distrust, right? And this is a question that requires not just lawyers, but sociologists and political scientists and anthropologists and others to talk about. So maybe we'll do an interdisciplinary panel one day. But I think just based on my reading, I would maybe, and this is from a sort of comparative human rights and democracy perspective, I would highlight maybe three things. One is, as I think Rick alluded to, if you look at, democracies, again, that have collapsed in other parts of the world or where there's been democratic erosion, one of the things that's most effective in pushing back against that decline is bipartisan, transpartisan alliances. So even though I disagree about a great many things with Liz Cheney, about a great number of things, right? Her behavior on this committee and that of other Republicans who have said, number one, there was no fraud in the last election. And number two, there needs to be ordinary rule of law type accounting and accountability to the extent that there was interference, right? Those efforts are extraordinarily important and should be embraced by Democrats. And indeed, not just Liz Cheney. I'm using her as an example because this week, she's been in the news. But there are many people who need to do that. And I think Democrats have plenty of across the aisle reaching to do as well. Transpartisan alliance, extraordinarily important around the kind of basic issues like actual elections in which both candidates have a fair shot, votes are fairly cast and fairly counted. Those are principles that are democratic principles, not partisan principles, and we should all agree on them. Two last things, countering violent extremism. So if you look at some of the most extreme elements of some of the January 6th rioters, some of these groups, some of the groups that are sort of most prone to violence, these are people who have a lot of issues surrounding them. And there are a variety of ways, not all successful, but we're learning more. And we've learned a lot in the sort of post 9/11 era about how we might effectively counter violent extremism. And I think those mechanisms are important. And then finally, the information environment. And this may be the subject of a whole other panel, but maybe we should talk about it specifically. It's not just social media is a huge problem, but it is not just social media. And particularly when it comes to false information about actual elections and the conduct of elections and speech that might interfere with, at polling places, for example, the conduct of elections and interference in elections. I think there is room, even under our robust First Amendment, for there to be more aggressive regulation here. So I'd start in those three places.
So I want to present a hypothetical here. We have in December of 2024, we have the Electoral College meeting in 50 states, 50 state capitals, and we have a group of, we can call them thugs, we can call them terrorists, we can call them partisans, we can call them Americans who are exercising their First Amendment rights, who gather around the state capitol and either intentionally or inadvertently prevent the casting of the electoral count, the electoral votes in that state capitol, throwing a real monkey wrench into what's supposed to occur on that day. Now, I'm being nice about it, but we'll assume that that's being done intentionally in order to stop the electoral count in a particular state where they don't agree to it. Is the only remedy for that going into court, seeking a mandamus? Or do we need to do what occurs in so many countries around the world and have mass participation by Americans in all the major cities in order to make sure that this process works? Is that the only way we can make sure that our election goes forward?
I mean, it's a hard question. I mean, it's wargaming essentially a terrorist attack on, election day or something.
No, but just think about this, Derek. You yourself, the people listening don't know this, but when a group of election scholars, including Rick, were discussing where we were, and I think it was in the middle of December, people kind of thought that, well, we managed to survive and everything would go according to the way it's supposed to, and Biden would be inaugurated on January 20th. And Derek said, I'm a little worried about January 6th. So you're pretty prescient about the problems. You were prescient about the problems we faced. And what I'm suggesting hypothetically is not so hypothetical.
Yeah, well, I wish I were less prescient, maybe. Let me start there. I mean, so I have like the academic answer, which is, well, in 1856, a bunch of Wisconsin electors couldn't get on a train because of a blizzard, and they voted on a different day, and they sent their votes to Congress, and Congress counted them after a little conversation, and we can understand and accept those things. And I would hope in those situations, Congress can do it. But I mean, what you're sort of identifying is the much more troubling thing, right? Like, if there's sort of attempts to, whether you want to say it's, 18 USC 241, 242, conspiracy to deprive people of their rights, to essentially interfere with federal activities, but in a much more concrete way than was happening on January 6th. What do we have? I mean, you require law enforcement and the National Guard and mandamus and as much rule of law as you can get to accommodate and provide for people in that circumstance, and pray it doesn't happen. But I don't have great legal answers, because it strikes me as such a cultural political question. Again, I have my academic question, but yeah.
But this is what people are worried about.
Well, I think there's a threat of violence that now is going to hang over the entire electoral process. I mean, you're focusing on one particular day, but look at what happened on January 6th. Look at what happened right after Election Day in Arizona, when they were still tabulating the votes, and there were mobs in front of election officials. And so it really is a deterioration. One question for me is whether this is now, whether this is a Donald Trump driven phenomenon, in which case, if we can survive the next election, we'll probably be okay, just based on actuarial tables. Or whether this has let the genie out of the bottle, and we're now entering into a period of potential violence and disruption of American elections for a generation. I want to believe the former theory that without a leader like Trump, that these things won't happen, but except in isolated ways that don't affect peaceful transitions of power. But I don't know. I don't think we know.
Would most of these problems go away if we abolish the Electoral College? Most of these legal issues that we've identified?
I want to say one thing, if I can, about the last conversation, and then I'll try to respond to this question. I mean, the short answer to the question you just asked was, do our problems go away if we abolish the Electoral College? Is no. And I think it's going to be extraordinarily difficult to abolish or even ameliorate the Electoral College, and certainly not on the 2024 timescale. But one thing about the Electoral College leads me back to sort of broader point about, where we are as a democracy, and whether this is a particularly bad historical moment, or whether we're on the cusp of a much worse historical era in American democracy. One of the problems with the Electoral College is that it entrenches it, along with the malapportionment of the Senate, for example, is that it entrenches or makes it possible to entrench effective minority rule, right? So we've seen now in the last, 20 years, repeated instances in which the person who won the Electoral College is not the person who won the popular vote in the United States, sometimes by quite a large margin. That, in global terms, is an unsustainable, that is to say, minoritarian rule, is an unsustainable position for a democracy. So whether it's through electoral college reforms or whether it's through, I think, likely to be more effective voting rights reforms at the state by state level, that's one of the big, I think, risk factors for democracy at the moment. The other reason I worry that it is not just Trump and singular fixes of things like the Electoral College, which is a problem, but not the only problem, are unlikely, is that as we see that it's not just a partisan split we're seeing. I mean, it is a partisan split, polarization, no question, but that a significant component here is identity and understanding of identity. And to some extent, identity as association with Donald Trump, but not just identity associated with Donald Trump. Identity factors on the basis of race, and communities that have larger influxes or are moving toward larger populations of immigrants and non-whites moving into the community, right? And there is just simply no question that race remains and is at the center of a lot of these voting rights rollbacks and restrictions on access to voting, and restrictions and abilities to deprive particular local election officials of power, and concerns, partisan-based concerns about the future of America and what we as a country look like, right? They say things in those terms, right? It couldn't be more stark. And that problem, which has been with us since the beginning, right, is a problem that Trump lit a fire under without question, but remains at the center of a lot of the disputes about who counts for voting purposes and how votes are counted and which votes matter and which districts matter. And that sustained identity-based division is another reason that I am not optimistic that the disappearance of Donald Trump in particular from the political landscape, now that he has been unleashed upon it, will suffice.
So speaking about being a non-optimistic, we've had the Supreme Court of the United States eviscerate the Section 5 of the Voting Rights Act, and Section 2 of the Voting Rights Act has been diminished in its effectiveness as well. And we recently have had a decision by the Supreme Court relating to partisan gerrymandering. And we all know that gerrymandering has enabled Republicans to win legislative seats on the state level and the federal level in a way that's disproportionate to the votes that they have received. Well, that's not necessarily a terrible thing, because Democrats have in the past as well, and the pendulum goes back and forth. But the effect of it has been these Republican legislatures, and I'm not being partisan, I'm making an observation, that these legislatures are enacting these various restrictive voting rights laws, as well as these laws that have the potential of subverting the election. So what do we do about gerrymandering, and in particular partisan gerrymandering?
Well, I mean, one thing I'd say is that Democrats do it less in part because they control fewer state legislatures. I mean, you could look at Maryland, and that, you know, they're debating, should we make it a 7-1 congressional delegation or 8-0? So,
and by the way, we can expect that to occur in New York as well.
Right. So you know, I think gerrymandering is a separate question. Certainly, there's a connection that when you don't have competition and in a general election, you have competition in the primary, and Trump can influence those primaries and put in place people who are going to embrace the big lie, then there's the connection. But I think it's important to separate out questions of election subversion from those of voter suppression. So Derek and I, for example, have very different views about how bad Brnovich is and how important Brnovich is in terms of what's going to happen with voting rights. But I think we can find common ground on questions about paper ballots or reforming the Electoral Count Act. And so while I think there's an important discussion to be had about these other issues, there's a reason to separate them, especially if you're trying to create cross-partisan coalitions.
Well, that's true, but the connection has resulted in the state that we're in.
Well, I'd say more that Donald Trump has resulted in the state that we're in, because as much as I wasn't happy with certain restrictive voting legislation, well, let me put it this way: I never expected Brian Kemp to be one of my heroes. Things have just moved to a whole other level. And, if you have to pick your battles, I'd start by preserving the Republic. And I think these other things, as important as they are, and I'm a supporter, for example, of the John Lewis Voting Rights Advancement Act, which is pending before Congress. I think it's secondary to dealing with this emergency.
Well, how else can Congress deal with this emergency? Will Congress? That's a separate question. And
those are two big questions.
Those are two big questions. Yes, I know.
They can do a lot. I think we go around, talking about the 800-page bills in front of Congress, omnibus bills, and we might have some different policy disputes or disagreements about the constitutionality of some of the issues. On a lot of things, there's probably a lot of consensus about things that might be wise or practical, but in an omnibus bill, it's an all or nothing. But again, I feel like everyone's been talking for the last 12 months and will be indefinitely about the filibuster in the Senate. And, I think that it's a question of will, and that's a different question, the question of what it can do. Again, maybe we can dispute some of the policy and discuss the constitutionality of some of the things that Congress is considering. But certainly things like paper ballots or reforming the Electoral Count Act ought to be the low-hanging fruit of bipartisan consensus in tidier bills. But that's not what we have right now. And so it's a different conversation.
So we're a little over our time. This has just been terrific. What I want to end on is the following. We're all teachers. We're all lawyers. I want to bring us back to Samuel J. Tilden, who got screwed out of his victory in 1876, 1877. But after Hayes took over the presidency, Samuel Tilden was addressing a civic group in Manhattan. And he said, well, I know that the person who won is standing here and the person who lost is in the White House. But if you can hear my voice, I want to say, be of good cheer. The Republic will survive. And for years, I would end my classes on election law at the end of the semester with that quote. I'm paraphrasing now, but I would end it with that quote and say that I choose to believe that the Republic will survive. I'm not sure that I believe it, even though I want to believe it at this point. What do you think? What do you tell your students? What do you tell all the lawyers who are listening to you today?
One thing I say is now's not the time for complacency. If you're worried, it's the time for action. And we still have some time. It's going to be too late if we wait till the end of 2024, but now's the time for action. And people need to wake up. Democrats in Congress and the administration need to wake up and start reaching across the aisle to those Republicans who are willing to work with them. And if they have to blow up the filibuster, whatever they have to do, laws need to be changed now. And as much as it can be done on a bipartisan basis, that's what there needs to be a push for. And everyone should be pushing for that right now.
Jumping onto something Deborah earlier mentioned about distinguishing poll watchers from poll workers. And I always encourage my students, lawyers, everyone, be a poll worker. Don't just be a poll watcher. Go spend, it's 15 hours. It's a long day working the polls, but it's a great experience to see the number of checks and safeguards in the process from the inside. you can be involved in the process of helping your neighbors in your community ensure that they can have a quick and easy experience of casting a vote in person, and ensuring that you're doing the counting at the end of the night to make sure that your polling place has done everything in its power to get the right results in a prompt manner. So it's very small, but I don't want to say 1,000 points of light at this point, but we want a lot of people to sort of be involved in the process and just be an influence out there.
Deborah?
Yeah, so similarly, when my students ask me questions like that, are we going to be okay, right? I almost always say it's up to you. And I increasingly mean it. That is to say, whether you go and volunteer to be a poll worker or sign up to be a poll worker, or engage in other ways. And I think today there are actually an extraordinary number of ways to engage, and they're all useful, right? As a former advocate and a former human rights lawyer, we used to talk about multidimensional advocacy, right? It's good to have both lawsuits and public protest and legislative activity and public campaigns with pop stars featured in song, because those different fora for protest and activity feed off each other and create space for each other. And if one finds the pop star campaign unappealing, another might find legislative activity more appealing than they might otherwise have found it. So I think there are a lot of options. The only the option, right, and there always have been, right? It's not that the civil rights movement was easy, or that the Reconstruction period was easy, or that the fate of the Republic then was certain. History gives this sort of false sense of inevitability, but in real time, nothing is inevitable. And it's a great moment for saying, and this is what it takes. So I'm on board. And if folks need more ideas, I'm sure we can refer them to websites and other activities that they might engage in. Waking up is job one.
We're going to let you have the last word. Thank you all very, very much. This has been very enlightening, very provocative. Thank you, the three of you, for being great friends, for doing great work in your field and inspiring all of us. And thank you all for joining us.
Thank you.
Take care.